photo ability.
Thank you very much. We thank the Special Rapporteur.
Thank you very much. Ladies and gentlemen, first of all, I would like to thank the organizers of the event because I believe it's very important to pay attention to the challenges which have been caused not by primary sanctions only, but the secondary sanctions as well. To address the root causes and assess the issues of legality and legitimacy of measures taken as a mechanism of enforcement of primary sanctions imposed currently by states and regional organizations unilaterally without authorization of the UN Security Council. And I also welcome very much the second part of the question, which is asked in the topic of the this side event about the possible solutions. Because we need to look for the way out of this situation. Unfortunately, today we are observing the dramatic expansion of secondary sanctions alongside the civil and criminal penalties for circumvention of sanctions regimes as a means of enforcement of primary sanctions imposed by states and regional organizations. Secondary sanctions became the instrument to ensure that all stakeholders, starting from individuals and legal entities up to states, follow and implement unilateral sanctions, although there is no legal ground for implementation of these ones. The utmost step in expansion of secondary sanctions, unfortunately, is the act which has recently been adopted by the United States Congress, so-called Syria Anti-Normalization Bill, which provides for the punishment for the countries which cooperate with Syria in one way or another. So it doesn't speak about secondary sanctions, but I believe that that's a new form of those which have already existed. I will, in a view of this short time what we have, I will only provide a few reflections about the problems which I see in trying to justify the use of secondary sanctions in one or another way. As secondary sanctions are used as a means or instrument of enforcement of primary sanctions, we need to analyze first of all the nature of primary sanctions. And as soon as nearly all of them do not correspond criteria of countermeasures, retortions, as well as are not supported or are not implementing sanctions of the UN Security Council, they all are illegal and constitute unilateral coercive measures. Therefore, we can't talk about legality or even legitimacy of means of enforcement of already illegal measures. Another challenge which I see in the expansion of secondary sanctions is the fact that they become even more extraterritorial than the primary sanctions as such. All countries around the world agree that extraterritoriality is against international law. However, those which impose sanctions state about the illegality of extraterritoriality but still apply extraterritorial secondary sanctions. There is also a challenge concerning the format how secondary sanctions are used. Quite often we do not even know that there are secondary sanctions unless we are subjected to them. Because the legislation of countries imposing sanctions, first of all, is extremely confusing and complicated, not even mentioning the fact that it's overlapping as soon as primary sanctions are usually imposed by several countries together and they do not coincide. The second challenge is that this interpretation, what can be assessed as circumvention of sanctions regime, is usually not fixed in the sanctions regulations. It's usually provided in a number of non-binding documents issued by executive bodies by various states. So formally they are not binding, but as soon as it comes to application of secondary sanctions, courts of these states as well as other executive bodies consider them as to be the law and apply them even if a person tries to apply for delisted in the face of unilateral sanctions. I won't mention other challenges which are similar for secondary sanctions to those which are faced by people designated under primary sanctions, like the very complicated and very expensive access to justice, challenges in delisting, and many other elements. I believe that the elements which I have already mentioned are sufficient to speak about the inadmissibility of use of secondary sanctions, and as such, when I address the bill which has recently been adopted by the United States, the Syria Anti-Normalization Bill, formally it doesn't speak about the use of force, but it contains a threat to any country which tries to normalize relations with Syria, and it's inadmissible and illegal as well. Looking for the solutions on this specific situation, I won't say anything new in comparison with what I have already said. To find a solution, states are obliged to act in accordance with international law. If states observe the rule of law, the majority of primary sanctions will disappear, and therefore secondary sanctions won't appear as well. That's the main approach. Point number 2, which is very important, is to address the issue of extraterritoriality, because secondary sanctions enjoy this characteristic of extraterritoriality even more than primary sanctions did. I won't go into details because we do not have much time, but we'll be ready to answer questions if they come in this specific case. Another mechanism and another way for solution is the full implementation of standards of due diligence and precautionary approach when states act at the international arena. And I do not speak about the due diligence to guarantee compliance with sanctions, and as it's currently presented by states which impose sanctions. I speak about the due diligence principle under international public law, which requests all states to act and to ensure that all entities under their jurisdiction and control act in the way which doesn't violate their international obligations, and which requests all states to make sure that any activity they are undertaken will not affect human rights both internally and extraterritorially. States can't act unconsciously. We can't speak that we didn't know what the consequences will be. We can't say that we didn't assess and we didn't intend to have this negative impact. States act in full capacity with all powers and therefore are obliged to do this assessment. Thank you very much, and I welcome the event once again and thank the organizers.
Thank you very much, Special Rapporteur, and I give the floor back to Fulya.
Thank you very much. Good morning, ladies and gentlemen. Well, today I wanted to talk a little bit also about the legality of the sanctions, both primary and secondary sanctions, but with the speech that we just had from Professor Duhan, so I skipped that part. And I start with a fact to go into the details of my presentation. Well, the fact that I want to highlight is actually in the time of COVID-19 pandemic, we witnessed the formation of more serious cooperation between states and the United Nations system to deal with the devastating impacts of UCS and condemn unilateral sanctions. However, after the Russian invasion of Ukraine, the situation changed, and sometimes it can be seen that sanctions imposed by the global north against Russia have been welcomed by the entire world. Therefore, it can be said that in the current situation, discussions about the legitimacy or illegitimacy of unilateral sanctions are more politicized than ever, and thus more difficult than ever. In particular, the European Union, which usually had a negative position regarding secondary sanctions imposed by the United States, as mentioned by Professor Duhan, has actually resorted to imposing some secondary sanctions against Russia. In this sense, discussions about the legitimacy of UCMs have become more important and difficult than ever before. In the continuation of the discussion, I will argue how the new debates in the context of human rights may be of use to provide additional justifications for questioning the legitimacy of the unilateral coercive measures. As mentioned and can be seen in the numerous reports by Professor Duhan and countries like Iran and Cuba to international forums, unilateral sanctions have very destructive effects on human rights. For example, country, Iran, the sanctions that the United States imposed on Iran after withdrawing from the nuclear deal in 2018 have caused severe economic inflation. As another effect of the sanctions by the United States, the Iranian rial has lost its value against foreign currencies. As mentioned in the country report of the special rapporteur, the increasing economic pressure inter alia has had an adverse effect on the access of ordinary people to basic necessities of life, as well as medicine and medical services. Therefore, from a humanitarian perspective, it can be said that rights such as the right to life and the right to health have been severely affected by unilateral sanctions. However, even though it is quite clear that it is the unilateral sanctions of the United States that have imposed these negative effects on the people of Iran, it cannot be easily said that the US is violating the human rights of Iranians. This is because there are serious differences of opinions regarding the extraterritorial nature of the human rights obligations of the United States. Moreover, accurately measuring the effects of sanctions requires complex data and calculations that are not currently available. Here I must point out that Professor Duhan is taking very important measures in this regard. Among other things, with the advice of lawyers and economists, her mandate is to provide a sample model to calculate the effects of UCNs on human rights. It is necessary for governments under sanctions and all actors against the unilateral sanctions to support this action in this field. But is there a way, legally speaking, to skip the extraterritoriality challenge? A point that may need more attention in discussing the relationship between UCNs and human rights is the actions that have been taking place in the Human Rights Council for some time to provide a new look at human rights. As you all know, Article 28 of the UDHR states that everyone is entitled to a social and international order in which the rights and freedoms set forth in this declaration can be fully realized. The realization of an international order, as emphasized in Article 28 of the UDHR, is itself a human right, necessary for fulfilling other human rights. The special rapporteurs of the HRC have done significant work in this field. Among other things, I must mention reports by Professor Zayas, who was the first rapporteur on the issue and who practically considered this order equivalent to an equitable and democratic international order. An international order in which human rights are prioritized and democracy is implemented, not only at a national level, but also at international level, including the relations between the states and international organizations. Professor Zayas and other reporters of the Human Rights Council emphasize two issues in order to realize this international order. Firstly, all actors in the international arena, including states and non-states, must play a role in this field. And secondly, cooperation among all actors in this field should be seen as an international obligation that is in line with other obligations of states to respect and ensure respect for human rights, and of course is mentioned in different goals of the Sustainable Development Goals SDGs. It seems that the debate on the legitimacy of unilateral coercive measures should be more closely linked with the discussions of an equitable and democratic international order. From my point of view, what is very interesting about an equitable and democratic international order is that it considers some of the obligations of states in the field of human rights to have a transnational character, and therefore provides a good argument to counter the non-extraterritorial nature of other human rights obligations. In particular, it should be noted that if we consider the realization of Article 28 of the UDHR in connection with the realization of an equitable and democratic international order, we can agree with some other rapporteurs of the Human Rights Council to promote those type of human rights obligations that impose international duties on all actors. Here, I would like to especially mention the work done by Special Rapporteur on the right to development and the Special Rapporteur on the right to international solidarity. If we carefully examine the work being done by these two rapporteurs, we are trying to define the right to development and the right to international solidarity in a different way from traditional human rights, or let's say the rights belonging to the first and second generations. In other words, despite the fact that in human rights debates, people should always demand the rights from the specific state under whose jurisdiction or control they live, in discussions about the right to development and the right to international solidarity, all states and even the international community as a whole are considered as agency of these rights and duty bearers. Professor Duhan has previously held meetings on the relationship between the right to development and unilateral sanctions, which I had the chance to attend. She has also mentioned this relationship in her reports. However, it seems that more attention should be paid to the right to international solidarity, for which the special rapporteur recently presented a new draft. According to this draft, it can be said that the realization of international solidarity is a prerequisite for fulfilling the obligations mentioned in Article 28 of the UDHR. Article 4.1 of this draft states that the right to international solidarity is the right of individuals and peoples to participate meaningfully in, contribute to, and enjoy a social and international order in which all human rights and fundamental freedoms can be realized. At the same time, as I stated in this new draft, the right to international solidarity obliges governments to ensure that actions or omissions by states and non-state actors do not harm the exercise and full enjoyment of international human rights. This is also true for discussions around the right to development as defined in reports by hrc54. Therefore, if more attention is given in human rights discourse, especially by global south countries, to this view that some rights, including the right to development and the right to international solidarity, are basically obligations toward the international community, then it will be easier to prove that UCMs contradict human rights because they clearly violate these two rights in a very gross way. Of course, I am well aware that this proposal faces very difficult obstacles from both legal and political perspectives, and therefore will not be easily realized. At the same time, in my humble view, it is necessary to pay more attention to these different readings of human rights obligations, especially regarding the right to development and the right to international solidarity. To begin with, it is crucial for the Global South to advocate for the adoption of the draft convention on the right to development and the revised declaration on the right to international solidarity. Due to time constraints, I will conclude my presentation by pointing out that target states should cooperate with each other and with thematic human rights rapporteurs to provide new interpretations of human rights and principles of international law in order to constantly confront UCMs with fresh legal challenges. During this process, opinions from international lawyers and governmental organizations can be very helpful. Thank you very much.
Thank you, Dr. Askeri, and I give the floor to Dr. Catherine Salish.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, distinguished member of the panels, and ladies and gentlemen. Good morning. We can still say good morning. It is a really privilege to participate in this panel, and I thank the organizer of this panel for inviting me. I would like to discuss today what has been raised by Dr. Askeri about the right to development, and I would like to focus on whether and how the right to development may affect the legality of unilateral coercive measures, or UCMs. In talking about UCMs, my discussion in this panel is limited to measures that are not justified in terms of legal countermeasures by the injured state, and that are taken when the international responsibility of the targeted state for the breach of erga omnes obligation is not established. In order to govern the legality of the UCMs, the right to development should either impose obligation on other states than the territorial state, or persons that their rights are affected by
obligations that derive from the right to development. This is because while development, as mentioned in many UN documents, including the MGDs, SDGs, and constitute one of the most important current agendas of the UN, this right, as enshrined in the 1986 UN Declaration, does not fit into any binding international instrument. Article 4 of the Human Rights Council 2020 Draft Convention on the Right to Development recognized the right to development as a universal right, which means that all states, as well as international organizations, undertake to respect, protect, and fulfill the right to development for all. On this basis, and in accordance with Article 28 of Universal Declaration of Human Rights, the draft convention under Article 13 recognizes a duty for states to cooperate and create a social and international order conducive to the realization of the right to development. This understanding of a right to development, as declared in draft Article 10, means that all states are obliged to refrain from any conduct that nullifies or impairs the enjoyment and exercise of the right to development within or outside their territories. Also, bearing in mind that UCMs and sanctions have a devastating impact on the enjoyment of all human rights, including the right to development, in Article 14, the drafters declare that states shall refrain from adopting, maintaining, or implementing economic, political, or any other type of measures to coerce a state in order to obtain from it subordination of the exercise of its sovereign rights in violation of the principle of sovereignty and freedom of consent, which constitute a violation of the right to development. But the problem is that these articles are not yet adopted in a treaty, and considering the practice of those states that use the UCMs as a part of their foreign policy, they stand far from being considered as a customary of international law. In their view, in the view of these states, the right to development, if exists at all, like most of the economic, social, and cultural right, does not necessarily apply outside the territory of a state. From this perspective, no state except the territorial state or the national state bears responsibility to preserve the right to development, and the sanctioned state is not under any obligation to take care or respect for the right to development or for the people living in other territories, including the inhabitants of the target states. This restrictive interpretation leads me to my second argument, which is to discuss whether it can be argued that the rights holder of the right to development may fall in a way under the jurisdiction of the sanctioned state. Today, a trend can be observed in human rights jurisprudence indicating that when a causal link exists between the acts or omission of a state and the negative impact on the rights, the enjoyment of the right of those persons located outside its territory, such person under certain condition will fall under the jurisdiction of that state. This reasoning can be well observed in the jurisprudence of, for example, the Committee on the Right of the Child, in the landmark case of hrc54 and others versus Argentina. The Human Rights Committee, as well in its General Comment number 36, states that when activities of other states could result harm in a direct, in parentheses, in a direct and reasonably foreseeable manner, such act would place that person within the jurisdiction of the state concerned. The direct and foreseeable harm of the sanction and UCMs on the right to development has been well documented. UCMs, which are mostly imposed on the developing countries by developed states, lead to wider gaps between the South and North. UCMs, as mentioned in the latest report of the Secretary General, have severe humanitarian consequences and adverse effects on vital economic sectors, thereby harming the welfare of the population. Secretary General further observed that UCM can aggravate pre-existing socio-economic challenges and have adverse impact on human rights and sustainable development. As also warned by special rapporteurs in 2020, sanction makes it harder for entire population to stay healthy, and hamper the transportation of goods needed for economic development, result in the waste of natural resources, undermine environmental sustainability, and achievement of sustainable development goals. In a nutshell, activities essential to every country's development suffer when unilateral sanctions are imposed. To conclude, in my opinion, even if we cannot adhere to the universal application of the right to development, there is no doubt that there exists a causal link between the UCMs and the negative impact on the right to development in targeted states. In this way, it can be argued that by taking such measures, the sanctioning state exercises jurisdiction over rights holders or over the rights of the persons affected, and therefore cannot evade its obligation to respect their right to develop. I conclude here, and thank you very much for your attention.
Thank you, Dr. Coercive, and I give the floor to Dr. Monsalvo Anibal.
Hello everyone, and thank you for inviting me to this panel. I'm very privileged to have a chance to talk to you about economic sanctions and its implication on human rights, and definitely the probable violations of international human rights and also international law and rules, specifically rules of international law. Because in general, if we want to make a country accountable for violations of its measures, first we should make sure that whether they're in compliance with the rules of international law. Sometimes we hear a lot, because just it is violating some international human rights, or even some human rights, we believe that they are the country is accountable, or the country should be held liable for those type of adverse consequences. But in general, if you want to talk as a legal scholar about the legality of economic sanctions, about the legality of the specific measures, first we should make sure that those economic sanctions are in violations of the rules, specific rules of international law. So where we can find the rules of international law? Definitely the sources of international law, which are mentioned in Article 38 of ICJ statute treaties, and also customary international law. So let's jump into the discussion that we want to talk about here today, and which is also in the name of this panel, about the legality of coercive unilateral sanctions and in their compliance with international human rights. So in general and historically, the first generation and the first wave of these type of measures, these type of coercive measures, they were blanket or comprehensive embargoes. All exports and imports from a specific countries or to a specific countries, it would be banned, boycotted, and then after a short while they found, okay, that's devastating and very horrific tragedies happening, for example, in the 1990s, and what have all international communities saw had happened in Haiti and also Iraq, and after that they found, okay, probably it doesn't work, or it doesn't work, even though maybe that some policymakers, they think that it worth the death of millions of people, but actually it didn't work. As a legal scholar, human rights activists, and even that at a certain point, policymakers, they decided to go toward targeted sanctions. They went there, but still there were lots of deficiencies over there. They found there are lots of procedural, even some substantive right that they are infringed by those targeted sanctions. And then they mentioned, okay, probably we should go toward smart sanctions. Those sanctions that they are mainly created to prevent you or to prevent some sort of other wrongdoings or subsequent wrongdoings. And but they found in reality still they are in they are more in favor of targeted sanctions. But the definition of targeted sanctions, which I also specifically mentioned in my research, are so different from the perspective of those countries that they are sending states and those countries that they are targeted states. So you cannot call sanctions, targeted sanctions that it is imposed against central bank of a country. So central bank of a country is not does just have like some certain shareholders. It has it has a very broad effects and several million like customers, and all of those customers, they would be affected by these sanctions. So you cannot call, okay, I just impose sanctions against all industry of a specific country and call it targeted sanctions, or central bank of a country and call it targeted sanctions. And the reason that I'm emphasizing on distinguishing between embargoes and targeted sanctions is that when we want to challenge the legality of sanctions, they are very crucial to know whether this is a targeted sanctions or this is an embargo. If that's just embargo, the legality is much different. The challenging aspects are much different rather than just targeted sanctions, which can be treated based on the due process infringement, like some classified information which are hidden, and then you can challenge in international court. So that's totally different. But regarding the embargoes, based on the paper's definition, not only those measures, coercive measures that they are against a specific country are considered as embargoes, but also those measures that they are against a specific sector, which has a broad like side effects, or it's better to be called micro. It's better to be called that macro entities. So they are also considered as embargoes. But those micro entities, those specific natural individuals, they are targeted sanctions. Where you are imposing sanctions against a small company, yes, that's definitely targeted sanctions. Or a specific person, that's targeted sanctions. But you cannot call sanctions which has broader effects as targeted sanctions and then challenge it in the way that targeted sanctions should be challenged. So that was something that was very crucial to talk about. Then we want to talk about those specific rules of international law that they may be infringed by these unilateral coercive measures. So the first one is treaties. So treaties could be bilateral between two countries, which, for example, the United States has bilateral countries with several bilateral treaties with several countries. And also, there are lots of sending countries that they have had in previous times, a good relationship with the country, and they made these bilateral treaties, and then after a short while they decided, okay, the country is changing its behavior or whatever happened between these two countries, and then they want to impose sanctions against that specific country. And also there are multilateral treaties, starting from United Nations Charter and going down to other multilateral treaties. In this model that I want to introduce, which is rights-based model of economic sanctions, which comes after, as I mentioned, comprehensive embargoes, then it went to targeted sanctions, then it went to smart sanctions, and now I want to introduce rights-based sanctions. So these rights-based sanctions, they should be in compliance with international and multilateral treaties, rights-based treaties definitely, and also they should be in compliance with customary international law norms. So both of these resources, they are very crucial to be considered when we're going to design, or in other way, we want to challenge the legality of some sort of unilateral coercive measures or a specific regime. So we should know whether these regimes, they are in compliance with these treaties and also customary international law. So the third thing that is crucial to know, when we want to challenge sanctions, we cannot just say, okay, unilateral sanctions are illegal, because unilateral sanctions are legal based on the findings of this paper. So we should go and specifically talk about each unilateral sanctions and each regime of sanctions to make sure that whether this regime, this specific regime, is lawful. If we are talking about this specific regime, we should see whether the regime is in compliance with the treaty between the two countries, that both of these countries, they should be member of that treaty. We cannot say, okay, there is a specific treaty that talks about unilateral sanctions, and they mentioned that we should not, member states should not impose unilateral sanctions on other member states of this treaty, which infringe the right to food or right to health, and say, okay, because one of these two countries sending a state and targeted state are a member of this treaty, then the targeted states can go to court, international court, and claim its right. No, definitely it's not going to happen based on international law, because the other country is not a member of that treaty. So in some cases, in some theoretical research, we see even this, this type of mistakes that some law scholars haven't made, and that's something very crucial to know, whether both countries, they have ratified to these treaties. Also, I mentioned about some other international treaties, which is good if you or other people, other law scholars, if they're interested, go through the paper and see what are those treaties. But in general, I reached to this conclusion that only those type of unilateral sanctions that they are aimed to change a regime, or their side effects is going to be equal to military blockades, they are in violation of international human rights, or those type of measures that they are against some specific terms or conditions or rules which is mentioned in bilateral treaties between two countries. For example, we have seen in the alleged violations case between the United States and Iran, the court in provisional measures part, they reached to this conclusion that those regimes, they are in contradictory with some terms of at least for provisional step and phase, they reached to this conclusion that United States should seize those type of measures that they're inflicting medicine and food in Iran, and also some other part of violation of some other parts of those amity treaty. So that's something to be considered. The second part is regarding customary international. Customary international law, based on almost all world's opinion, is created by not only state practices, but at the same time opinion jurists as well. But United States as the main imposer of sanctions, they believe that only customary international law is created by the state's practice. So again, that's very crucial in analyzing the legality of sanctions, because according to United States, and also in some cases we see that in practice, which I touched shortly about. But in general, we cannot say and we cannot make a country accountable based on its practice if the country doesn't believe that, for example, the customary international law is created by opinion jurists as well. We see, in UNGA, in the United Nations General Assembly meetings on almost now on yearly basis, they are condemning developing countries. They are condemning use of economic sanctions. But when we see that there are persistent objectors, and based on the rules of international law from one part of the world, they believe that persistent objectors, they are not accountable, or they are not obligated to follow a specific rule. So definitely United States is not obligated to follow this type of that even illegality assumption of unilateral sanctions, because they are persistent objector. So they should challenge this. And also on the other hand, they believe, and also in reality we see, and there are those countries that they are against imposing sanctions based on their opinion jurists, or based on in some cases based on their opinion, or based on their words. Economic sanctions, unilateral ones, they are unlawful, but in practice we see that they are imposing economic sanctions as well. So you cannot say this is unlawful and use it at the same time. And also we have enumerated some of these episodes and mentioned that although the countries that they are imposing these measures, they believe that this is countermeasure, but as legally speaking, they are not countermeasure, because countermeasure has specific elements based on the rules of international law. So also this is something that we should consider in challenging the legality of economic sanctions based on the customary international part. And at the end, I reached to this conclusion that economic sanctions, while they should not be mixed with economic freedom of countries, because all countries are free to do business with other countries or do not business with other countries. So sometimes, in one analysis, we mix these two concepts. Economic sanctions, and also it is mentioned in the name of this panel, they are coercive measures. Okay, and they are totally different with retortions, which are just unfriendly acts. Okay, but they should not be in violation of some other treaties, like commercial treaties, for example, between these countries. That's totally separate issue. But that's something that should be considered as well. But at the same time, we should know that if sanctions, they want to be in compliance with rights-based model of sanction, they should go through all these steps. They should make sure that they are in compliance with international human rights treaties. They should go and make sure that they are in compliance with customary international law. And if they are, they should at the same time be precise, exactly against those wrongdoers. They should not be like, that, and they should not have some other side effects. And maybe that in practice, it's hard to implement these type of words or thought, but definitely in the future, we law scholars, we can that develop this idea and make it more efficient and more practical, that both sides of the debate, they know that economic sanctions in general, it should be lawful to prevent war. But it should not be used in a way that also diminish the values of economic sanctions at the same time and decrease its effectiveness. We see that the efficacy rate of current economic sanctions is extremely low. Every day they are decreasing, in terms of efficacy rates, which have been studied by several countries, and definitely main studies that came from the United States that they show the bad record of efficacy of economic sanctions. We want to make it stern. At the same time, we want to make it with lower side effects to innocent people. Definitely that's our goal as international law scholars. So I hope this probably paper, but also this topic that I talked about was useful and also created some sort of preliminary step toward making this subject more developed. And thank you so much for giving me the time. I hope I was within the boundary of time. And again, thank you and have a good day. Bye.
Thank you, Dr. Rouhani. Any question from the floor? Yes, please.
Thanks very much. Can you hear me? Yeah, I'm Mercedes Rossi from Associazione Comunità Papa Giovanni XXIII, PG23. First of all, I would like to thank the panelists, the organizer of this event, for the inputs, wonderful inputs. And I've got one question for all of you, especially the special rapporteur, Ms. Moran. You know that the international covenant, the draft international covenant for the right to development that will be presented if we go to the General Assembly, put in Article 14, as the Dr. Hussein mentioned, the issue of the unilateral coercive measure ordinance. I would like to ask all of you your opinion on this article, if it is, do you think that it could have been more elaborated or for the time being it can be a good move. And I would like to thank very much Dr. Piera Turia Ascari for mentioning the importance of the Convention on the Right to Development and the Covenant, and especially the right to international solidarity, the revised draft text, because they are really very important tools, at least for us as civil society, that we have seen to advance this cause, including the one of unilateral coercive measures. And I would like to ask you this question. What do you think we can do? Because rightly you said that these are issues that are quite difficult to make advancing here at the UN. There are a lot of obstacles. Which suggestion do you give to us as civil society that are focusing on this important cause for making it to advance? I mean, what are you suggesting? Thanks very much.
Excuse me, Mr. Chair, can I ask you a question? Yes. Dr. Professor Durman, I would like to ask you a question. At first, we would highly appreciate the establishment of the sanctions research platform and the assessment tool. On the assessment tool, I have a question. I would like to ask you if your mandate would consider the documentation which is going to be done using the assessment tool as any first initial step toward establishment of a compensation mechanism or something like that, or your mandate would consider such a goal to be still far from the reach. Thank you very much.
Thank you very much for these questions. As concerns the convention and the draft convention on the right to development, I believe that the very fact that the unilateral coercive measures are addressed in this convention is already a huge step forward, because traditionally they are not addressed at the level of international treaties at all. And to tell the truth, in the current political world, I do not believe that, for example, the idea which has been proposed by my predecessor to develop a convention on unilateral coercive measures is feasible in any foreseen future. That's why any step forward provides us for the possibility to establish certain legal framework and to establish the approach, to build up the approach. The previous speaker was talking about the attempts to ensure that the attempts to prove that the customary international law has been created because everyone is imposing unilateral sanctions. In reality, there are legal mechanisms which prevent states from doing that, and I would refer inter alia to the draft conclusions recently developed by the International Law Commission on the use Corbyn's norms of international public law, which clearly say that illegal activity and illegal practice can't establish an international custom. But nevertheless, the very fact that a treaty, if it ever has been adopted, contains the assessment of unilateral coercive measures as illegal will be a huge step forward. As concerns the sanctions assessment platform, well, it's still a long way forward. We are at the initial step, and you have seen that there is a call for contributions on the back page of the mandate. In reality, no one ever did it. So we are establishing something new, and we try to find the way how to make this mechanism functionable, not to exist as methodology with hundreds of pages explaining how nicely academically it's done. We want to have a practical tool. That's why I'm welcoming all of you to contribute how to make a methodology, and the next year, when the thematic report of the mandate will focus on a field trial of this methodology, to submit your contributions to see how it works. I would say I can't say no to your question, but I can't say fully yes, because even the establishment of this tool for monitoring and assessment needs time. No one ever did it. No one knows how to do it. No one knows how it shall look like, and how to make that it's assessed with respect and it's accepted with respect. So, but what I can say and what I believe is important, in order to talk about any sort of responsibility, accountability, and redress, we need to know what is the damage caused. That's why I hope that in the future it can be one of the tools which will be used for the issues of responsibility and redress, but it's still a long way forward. That's why to be able to identify what tools can be used, that's why my second thematic report for 2024 will focus on the access to justice. And one of the challenges, one of the problems which I have already been informed about, those who have been directly designated have very limited but still some access to justice. Those whose rights are affected by secondary sanctions, over-compliance with spillover effect, have no possibility to get access to justice, because as soon as they try to reach out any court, they will say there is no document which affects your rights, there is no specific act which affects your rights. So you have
if the question is what the civil society can do to make sure that the draft on the international solidarity and the draft convention on the right to development will work, I want to say that, well, we have at least 3 unsuccessful experiences. In 2013, we have the Arms Trade Treaty. In 2015, we have the Paris Convention. In 2017, we have the Nuclear Weapons Convention. And if you see these 3, you can see that, well, there are big differences. Now, the civil society can say that we pushed and it worked, and the governments, because of the pressure that we put on them, has adopted these 3 very important treaties to regulate the arms trade, to combat the climate change, and also to ban the nuclear weapons. But from this point of view, from, let's say, symbolic point of view, yes, I fully agree. But the reality is, all of these 3 examples that I have said are unsuccessful when it comes to the reality, to the practice. So the only message that I have is, this is now the new trend of the governments. They say that, okay, there are a huge pressure from media, from the international community, from the civil society. So what we have to do is to adopt something which is nothing, but to tell them, yeah, you had this pressure and you can see it is working. So, right to development, right to international solidarity, as I have mentioned, are international rights towards the international community as a whole. If they adopt something under this, then it doesn't work. So you have to be careful. I mean, to have the title, to have the convention adopted is not enough. We have these experiences. Thank you.
Thank you very much.